reverse sexist assumption in my mind, but I just find it awfully hard to tell somebody who gives me an eyewitness identification that you could be wrong. And so I accepted that conclusion. But I did tell both Gene Fogel and Rod Hansen that it is bothersome. And if you could get me anything else that sheds light, if there are any other possible perpetrators. And they said, well, actually, we've got some private investigators showing that there's a possibility that this woman was possibly involved in the prostitution trade, maybe buying and selling drugs in Northeast Detroit. And there's some evidence that we have that instead of being an attack by her ex-boyfriend, that this was in retaliation for her not paying some debts. And the story almost sounded too good. It was like almost out of the movies. And again, now I have this victim who is now, the defense of this case is not only asking me to disbelieve her, but now they're starting to diss her really badly by talking about these other things she could be. Now, granted, if she's into this, again, that doesn't excuse whoever attacked her, but it does give an alternate explanation which probably deserves some review. But on the other hand, that's why you have trials. But I suppose the argument back was that, okay, but the first trial was flawed because the bite mark evidence was flawed. So I'm like in a perfect quandary, haven't really gotten enough to push me over, but I say, look, it certainly deserves something more. I am not going to just stipulate to a new trial on the basis of a couple of reporters, no offense guys, but you know, you got your business, you put together your series, I believe that you're acting in good faith, but I need to see some harder evidence. And what I suggest you do is, says, Rod, you got connections, get this guy a good quality defense attorney, have him or her come into my office, we'll sit down, we'll look at the evidence, I'll go over this with my prosecutors, and we'll figure out what to do. And so he says, fine. Okay. And that happens in 1997 at the close, and then like 1998 rolls by, and again I don't hear anything, and then 1999 comes around, and finally there is a motion that a defense attorney files for a new trial, and attaches a lot of persuasive stuff, including some polygraph results, including some investigations giving credence to the possibility that other people could be the attacker. And now we're finally going somewhere. And I think to myself, okay, we're going to maybe not have a trial, but on these 6,500 motions, the trial court judge can set a hearing and will actually have witnesses come in. And we can cross-examine those witnesses, and we're going to have a chance at real justice here. Okay. Unfortunately, for the cause and the abstract of justice, it is permitted, and again, this is kind of the arrogance that the system has towards any post-conviction relief. It is permitted for the judge to decide these without holding an evidentiary hearing. And the judge decided that I think so little of these affidavits and this presentation that I am not even going to hold an evidentiary hearing. So we don't get to hold an evidentiary hearing at that point. The case is delayed in going up to the Court of Appeals because by this time other cases involving Dr. Alan Warnick are going up to the Court of Appeals, and the defense attorney, even though he gets denied by the circuit court judge, figures that it's to his advantage to wait till these other things come down because before he takes this one up, we'll get some favorable rulings. And he delays. There's another year that goes by. Finally, we get into the year 2001, and I have a sit-down now with this guy by the name of John Royal, the defense attorney, who brings me all of this material. And in preparation for this, I write out a kind of a one-page summary, but it's persuasive. It's a one-page summary of all of the evidence that would go the other way. And so I meet with this guy, and we go over this back and forth, and his plea to me is that, you know, look, we have to do something to get an evidentiary hearing so that these witnesses can actually be examined. And I said, well, I'll tell you what I'll do. I will meet with these new witnesses that you've identified. The people who say that they saw this victim involved in prostitution in Northeast Detroit, I will sit down with those persons. I will sit down with the alibi witnesses for Mr. Muldowan who testified at the first trial, and I will see if I can make some kind of determination as to whether or not I believe that there's enough in their story to permit me to take some extraordinary request to the judge to grant an evidentiary hearing, even though he didn't want one. And so in, I think it was April and May of 2001, I actually do this, and I have a meeting in the little conference room in the office with a number of these witnesses. They come in. And the bottom line after it's all over is they say, you know, these people could be right. On the other hand, alibi witnesses all suffer from one common flaw, and that is that while they are sure that this person was with them and not available to commit the crime because they were with them, you have a problem locking in the dates, because why is this weekend different from any other? In this case, the chief alibi witnesses were pretty good because they said they just came back from Niagara Falls, and so there was a reason to lock it in. But also, the time element was so hard to pin down because this assault could have occurred just after sundown, it could have occurred at 11 o'clock, at 1 o'clock, at 2 o'clock, at 4 o'clock. And so you had an alibi that in part depended upon believing that while these two adults went to sleep, Jeffrey Muldowan was up with some little kid playing video games, and it still wasn't conclusive, but it bothered me somewhat. So what I suggested then to the defense attorneys, I said, look, I am still met with this problem, and that is that not only the victim, but the victim's sister gave testimony in the trial. The victim's sister said that this Jeffrey Muldowan, the former boyfriend, had called up and on several occasions had threatened her sister. And that on the day in question, there was a call that came in before anybody knew that the victim had even been hurt. And Jeffrey was saying, I want to talk to your sister. By the way, I'm not using names because it's still ingrained in me as a prosecutor that you don't use the names of actual victims, whether or not you ultimately believe that the crime was committed. So I'm not going to, other than the defendant, because that's a matter of public record, and eventually he gets exonerated. I gave away the story. But anyway, I say to, oh, and by the way, while all this is going on, all of these years, this guy is obviously sitting in jail, serving his 60 to 90 years, so you can just imagine what life is like for him and for the members of his family. But I tell the defense attorney that, look, at the victim's sister said that a call came in which Jeffrey said, I want to talk to your sister. This person said she's not here, and then he laughed and said, yeah, I know she's not there, she's in the morgue, and he hung up. Obviously, if that call came in at the time before anybody knew that there had actually been an assault, that knowledge of the crime having been committed, in addition to the other stuff, is pretty conclusive that this guy knew about the crime when he shouldn't have, and we as prosecutors use that all the time to say that, well, that shows that he has knowledge that he shouldn't have, therefore he's guilty. However, there was an explanation. The explanation is that Mr. Muldowan admitted that he called, but he called later on in the day when the news had already spread about the assault on the victim, and he was expressing concern that, you know, I hope that she's not in the morgue, or words of like effect. And sometimes that happens. This is why you have trials. People remembering the same conversations in different ways. Or you have the